Hello, Dr. Bechtel here. This is the fourth of a four-part series on legal, timekeeping, and billing practice, and this time we're going to cover timekeeping practices. This is so important to know. It's probably one of the main things a paralegal needs to know about the time and billing process, to be honest. Of course, trust accounts, really super important to identify all that, but in this lecture, we're going to talk about the core timekeeping vocabulary. Had a little bit before in one of the other lecture one, but we're going to go into the pieces that are most essential for this topic again. We're going to show how to differentiate between billable and non-billable tasks. We're going to apply some standardized timekeeping practices from my experiences and recognize the impact of the United States Supreme Court case of Missouri versus Jenkins, a 1989 United States Supreme Court decision. And we're going to explain how to describe the work performed in preparing time entries. So our terminology, we have billable hours, that's the work spent for clients. Non-billable hours are administrative internal tasks, not charged to clients. Excuse me. The hourly rate, that we've talked about that in one of the earlier lectures, but that's the fee charged per hour of work. A matter, that's the specific case or project that's being tracked for billing. Time entries, we're going to go into how we record that work in increments, tenth of an hour increments. And so moving on. All right, let's begin with billable versus non-billable time for paralegals. And once again, billable time are substantive legal tasks that require training and legal skill. All right? Non-billable time, that is administrative or internal tasks. And these are the tasks that support the firm, but don't directly advance the client's case. Sometimes it is definitely for a client's case, but that's when you still need to differentiate between whether it's billable versus non-billable. The United States Supreme Court case of Missouri versus Jenkins at 491 U.S. 274. It's a 1989 case. It was a breakthrough case that legitimized paralegal billing at market rates, and it reshaped law firm economics and professional recognition of paralegals. This is a really, really important decision to paralegals. The court held that time spent on a matter by paralegals and law clerks can be charged to the client at market rates, and that's per the Civil Rights Attorneys Fees Award Act, 42 U.S.C. Section 1988. The reasoning for this is compensating paralegal work at market rate encourages cost-effective delivery of legal services and recognizes the substantive contributions paralegals make. The impact is great. It was validation, finally, for paralegals as professionals whose work carries independent value, ensuring firms could bill their time ethically and recover fees in fee shifting cases. So fee shifting means that loser pays. Okay, so there are times that's where that act comes from, Civil Rights Attorneys Fees Award Act. Not necessarily with fee shifting, but it is with fee shifting. I'm getting kind of rambly here. Point is that when you have a trial or a case, that whatever it is, that you have to prove up your fees because maybe the statute that the case is falling under, that the claim is falling under, has fee shifting, loser pays. Then you would need to establish with the court so that the court can make a decision on whether those fees are reasonable. Well, in this case, Missouri versus Jenkins, they fought the other side that was getting the fees shifted to, said, wait a minute. These are paralegals, they're not lawyers. Well, you know what? We took care of that argument that day in Missouri versus Jenkins. All right, so what do we mean by these standardized increments? Well, firms, almost all, will do this in tenths of an hour, which a tenth of an hour equals 6 minutes. It used to be a little more common to use quarter hour increments, but we realize that some things are just taking a second or a minute. It needs to be billed, but to bill 15 minutes for it when it was only a 6-minute job or even a 10-minute job clients are getting bills for something that's not really happening. So it is I don't know if anyone's doing that anymore. But years ago when I started paralegaling, that was not uncommon. All right, so when you're recording your time, there's so many important principles I want to stretch into this lecture. Be specific when you describe your work. Note it clearly. Yeah, okay? Also notice action verbs. Start every single time entry with an action verb. We'll have more examples of that in a minute. And the separate tasks. So clients will have a big fat black and white cow when they get a bill with a task that is a page long, typed, right? So, and that's because, well, and what you need to do as a timekeeper is ensure that you're logging specific activities separately. So even if you spent a whole day on the client's project, a project for the client, you would want to break it down into this distinct activities that took place in that 8-hour day. Reading and reviewing contracts, for example, and then the next project might be drafting the complaint. All right, so you would want to do those two separately. Include in your time entries the matter codes. Now, if you're using a time and billing application software, it's going to ask you for that anyway. It's also not unwise to, while you don't bill for non-billable time. Your firm won't be billing for non-billable time that you spend. But it's a good idea to write down the billable and the non-billable. You might not use a billing system per se that the firm is using for your non-billable work, but I kept a journal. I just kept a journal at my desk, and it helped me track that productivity and firm efficiency arena, and it would also help explain some things like some slowdowns in my work, in my performance. I maybe at that month it was really heavy on some library administration I had to do. Law library firms will have a law library many times, and there's often a paralegal assigned to handle this the work. It's not quite the same as it used to be in a physical space. But anyway, that's what I'm talking about. Here are some examples of how to record time examples. Again, notice that these are all beginning with an action verb. All right. Now also notice that they aren't two words. Read and review letter from Attorney Smith. Oh, okay. What was that letter about? The client's going to say, you read a letter, and it could have been a half an hour that you're putting down for that. Well, clients don't want to pay for you to read and review something. They really don't. But what did you do? Oh my goodness, it had to do with the settlement of a case. And I'm not saying that's a feed for you'll feel better because I'm going to try to settle your case when you get the bill. But more that it shows some real work, some thinking, some expertise you had to put to work. Review and analyze letter received from Attorney Smith regarding a possible settlement. So that's saying, oops, it looks like I may have. Oh, see, and this is a good idea. You might have read and reviewed, or you might read and analyze. That's just two different ways to do it. Prepare or draft a letter to Attorney Smith in response to his letter. So look, I'm being clear about what the target is. Meeting with client to discuss what you discuss. Meeting with client could be written, but they don't want to know that. They know they were there. What did you do? Even if they were there, they want to know what you did. So just in case they forgot. Okay? Anyway, here's some juicy ones, like research automobile and negligence issues as related to drinking and driving. Telephone call to Ms. Potter. You can tell I wrote this a long time ago. There are two spaces after the period, and I'll just tell you right now. Strunk and White, which is the manual of writing that's used in the NALA exam the skills exam. There's only one space after the period. How did I find out that there's only one space after the period, and why does everything in the old days have two spaces? Well, because I thought it was two spaces, and I went my whole life like that. And when I wrote my dissertation, I found out there's just one. So by golly, I'm going to fix that. So you can see when I've written something a long time ago. Timekeeping practices. Okay, so just some final words. take the function seriously. Find out how many hours you must bill annually also. It's really important. When you come to work at a firm, they may tell you need to bill out 1,400 hours a year. Whoa. So what do? You divide that 1,400 by 11 months instead of 12 months to figure out what you need to target for on a monthly basis in billable hours. That buffer is there for vacations, for times when the billable work is just not coming, for illness, that kind of thing. Contemporaneous timekeeping, folks. I've said it before. I'll say it again. This is just the most essential first step to keeping track of your time. Do it the minute you finish the work. And it's the only way you're going to remember anything. You cannot wait till the end of the day and go, oh, what happened here today? You can try, but it's not going to be accurate. So remember, that's illegal. Accurate time is legal. Inaccurate time is illegal. And that's because the client does not deserve to be billed for something that took you half an hour and you put down an hour because you really just can't remember how long it took. Just felt like it was an hour this time around. All right. So time you actually spent is why it needs to be contemporaneous. First you remember, and then you can be accurate with the amount of time you spent. It's not your decision to record the amount of time that you think should have taken. That's when the write-down process comes. You can write a note to your attorney in the billing description that says, I think this took too long. You can do that, unless your lawyer tells you never do that. But that's for that pre-billing stage where you get to look at it. And you might say, I got interrupted every time I turned, or maybe I wasn't feeling well. It's okay to tell my attorney, I was not in my prime. I had an upset stomach, but I did it anyway. Anyway, do not bill for work you did not perform. I think this is our last slide for this one. Yes, indeed, it is. I am grateful this is over. I have worked on this slide presentation for many hours because I wanted it to be improved so much, and I hope that you got a lot from it. This lecture series was the one that just really needed to be upgraded and updated, and I noticed while I was lecturing I still didn't catch every single thing I wanted to catch. But nobody's perfect, and have a beautiful day. Thank you.